Hello, kia ora, Lucia here, property investment mentor and founder of the Finax Mortgages and Insurance. This is the recording of 1 hour live webinars. If you would like to join us in our next webinars and be part of the Q&A, please head to our website, luciaxiao.co.nz. I trust you will definitely learn a lot from this video. Thank you. Good afternoon, everybody, and welcome to our today's webinar, how to protect your assets under the new trust law. So for those of you who had not met me before, I think some of you probably haven't actually met me before. So my name is Lucia Xiao, and I am the property investment mentor, financial advisor, and founder of Finax Home Loans. And also I am an author as well. So last year I published my book, Financial Freedom, 5 Steps, 5 Years, and pretty much just my my personal story actually from living in a state house until later on I built a $17 million property portfolio in 5 years from 2012 to 2017. So if you are interested in the book, let us know. I will put our contact detail on the chat box there. And so joining us is actually Vicki. So Vicki is only specializing in the trust law, nothing else. Vicki doesn't do like house transitions or, and Vicki is, have over 20 years in trust. So I'm probably going to let Vicki to just, introduce herself and take it from there. Okay, all right.
Thank you. And it's so the point of today's presentation is that it's been interesting from the poll how many of you don't have a trust. So that's actually been really interesting, and it helps me work out what you might want to hear about today. So there's two aspects to today's presentation, and the first is what people need to be doing if you've got a trust, and what you need to know about some very important changes in trust law in New Zealand at the moment. And for people who don't have a trust, through today's presentation, that's going to give you more information about what it actually is when you've got a trust, why people do it, and maybe how to decide whether or not a trust is the right thing for you. So from a practical perspective, a lot of people don't know much about trusts. They get trusts, and that's why we put the questions we did in the poll. Often because if you say to a client, well, why have you got a trust? The usual answers are, I don't know. It's just, everyone else has got one. Or my lawyer or accountant told me. Sometimes people might settle a trust or create a trust because they've had a relationship breakdown, and it may have that it went they fared very badly in it, or when their relationship ended, they had a relationship where maybe all of the assets were jointly acquired, but they've got children, and at the end of that relationship, big concern is, if I have another relationship, I don't want that person to get the assets that I've already got. And so they might settle a trust that those assets are kept out of the relationship. Or it might be because they want to provide for their children in the future. Or sometimes people do it for tax reasons. Sometimes people do it because they think that when they're old, that will get them a residential care subsidy. There are lots of reasons. Some reasons are good and some reasons are really bad. And so before we talk some more about reasons to have a trust or not have a trust, I'm going to talk just a little bit about the Trusts Act. The Trusts Act is a new act. It was enacted last year in the middle of 2019, but it doesn't come into full force and effect until 30 January next year. And the reason that there is such a long transition period is so that people who've got existing trusts have got time to work out what changes they might need to make. And the Trusts Act, and what's considered the purposes of the Trusts Act, is the idea behind it, or what the Law Commission and then the government wanted to achieve with the new Act, was that they want to have the main principles of trust law in one piece of legislation, And they wanted what they've called these default administration roles, so that trustees who take on the role of a trustee actually know and have got somewhere to go to tell them what their job is if they are a trustee, and also if there are disputes. Because over my career, at the start of my career as a trust lawyer, there might have been a handful of cases each year that came out of the courts because there'd been a trust-related dispute and it ended up in court. Now, there might be 5 or 10 every day. There's been a huge explosion in the amount of trust litigation, and there's 2 reasons for that. The first reason is that we have a lot more trusts. The second reason is that New Zealanders started adopting trusts in about the 1990s. And a trust at the moment can last for about 80 years. There were some really early adopters who created trusts perhaps back as early as the 1950s or 60s, but that's not that common. But in the 1990s, trusts started to become really popular. They were tax effective, and there were also, the other reason people were settling trusts then is back then we had estate duty. And so people who had, were wealthy and had assets settled trusts because they didn't want to have to pay estate duty on their death. Estate duty has been abolished now, but that didn't stop people settling trusts. So after that estate duty reason, tax stayed a reason, and then concerns about relationship property, and also people who thought, if I've got a trust, then I'll be able to get a residential care subsidy. And some people, because as they've amassed more wealth, they had concerns about ensuring long-term asset protection, and it's sometimes referred to as long-term intergenerational asset protection, so that the assets that they amass are protected, not just during their own lifetime, but for their children and maybe even their grandchildren after that. And the Trusts Act talks about an express trust. An express trust is just another word for a trust. So sometimes it might be called a family trust or a discretionary trust, trading trust, business trust. People give them all sorts of names. So long as they meet the criteria of what it is to be a trust, that's all that is required. So if you've got a trust, the most important document or the core document is the trust deed. What the trust deed is, it's just some pieces of paper that set out the rules for the trust. And at the moment, if you've got a trust deed, the trust deed is what says, for example, things like who created the trust, who the first trustees are, who the settlor is, who the beneficiaries are, and what the rules are. And they're normally fairly standard documents. But there are some really important things in a trust deed that it is essential to know. So if you are a trustee, and for anyone who's not familiar with trusts, the 3 main people in trusts are the settlor or settlors, and they're the people who settle the trust. They are not the people who necessarily, they're not necessarily the trustees, but they can be. And then you've got the trustees, and the trustees are the legal face of the trust. And so in many ways, the trustees are the trustees are like the managers of the trust. They're the ones, if a trust owns property, it's the trustee's name on the title. If the trust owns shares, his name, the company's office. And then the third party is the beneficiaries. And that's who it's all there for. And if you're the settlor of a trust, you might be a beneficiary, but you don't have to be. You might be a trustee, but you don't have to be. But as the settlor, you're the person who decides what the rules are. And these rules are recorded normally in a trust deed. And so now, in light of the Trusts Act, one of the first things you have to think about is under the Trusts Act, there are new rules about holding on to the trust deed. So it's not enough now to say, oh, well, my lawyer will have it or my accountant will have it. What the Trusts Act says is that no matter what is recorded in the trust deed, every trustee must hold a copy of the trust deed and any variations. And at least one trustee must have all of the trust information. Now, what we don't know yet is that if, say, you've got a lawyer or an accountant who's got a good client portal or good document retrieval system so that they're holding all the records. Is it enough if your lawyer or accountant has got everything, or do you actually have to have those documents yourselves? And from my view, the safest presumption here is that every trustee must at least have, not just know where it is, but actually have a physical copy of the trust deed or a link or an electronic copy that they can access on their computer. And at least one of them must have all of the trust documents. And what might those documents be? That's things like deeds of appointment and retirement of trustee, the trust accounts, the information or that records what property the trustees own. If there's a memorandum of wishes, which is a letter or memorandum that the settlor writes saying to the trustees, if I've died or I'm not a trustee anymore, this is what I want you to do. And a memorandum of wishes, it's not as strictly required to be adhered to as the trust deed, but it is a really sensible thing to have because it gives the trustees, far more guidance than a trust deed. Trust deeds tend to be written in often quite archaic or old-fashioned sort of language. And the reason trust deeds are generally written like that is that while it sometimes doesn't make a huge amount of sense to our clients, the words used are used because if you're a trust professional, you know what they mean. However, big change in the Trusts Act. So moving forward, the Trusts Act is written in far plainer English and is far more understandable. But no matter what your current trust deed says, from next year, once the Trust Act comes into full force and effect, even if your trust deed says one thing, if the Trust Act says another, it is the Trust Act that will be the rule. So trustees moving forward will need to be familiar with the Trusts Act as well as the terms of the trust deed. And I'll give you a simple example of what that means. The trust deed might say, these are the trustees, but none of them have to hold the trust deed, so long as, it might be a trust deed that's very simple and says, I'm settling a trust, these are the trustees, these are the beneficiaries, and the trustees don't have to do anything unless the settlor tells them to, or they don't have to hold any documents, they'll be told what they need to do. Now, if that would be an unusual form of trust deed, but I have seen some as simple as that, but that wouldn't work moving forward because the Trusts Act doesn't allow you to have a trust where the trustees don't meet the rules set out in the Trusts Act. So for a lot of trustees, now is a time to think about, do I really want to be a trustee anymore? And there are other reasons to think about that I will touch on throughout this webinar. So I've talked about the settlors. If we go back again to the start of a trust, at the beginning of a trust, for a trust to exist at all, it's not the trust deed that makes it exist. That is just the rules. That is just a record of what the settlor intended. And most trust deeds will refer to what's called an initial settlement. And in New Zealand, that is commonly the sum of $10 or maybe $100. And the words in front of you are the sort of words you'd see in a trust deed. That says that the settlor or settlors have paid into the joint names of the trustees the sum of $10 to be held by the trustees upon the trust and with and subject to the powers and discretions set out or implied in this deed. Now, there's a couple of really important things about that statement. The first is the sum of $10. It's actually got to exist. And very commonly, people get a lawyer or an accountant to prepare a trust deed for them, and it's got words like this in it, but they don't actually get that $10 and put it into a bank account. And while it might seem, $10 is kind of nothing, who cares? It's actually incredibly important, and that's been confirmed by the Trusts Act, because what the Trusts Act says is that a trust doesn't start until the trustees hold property of the trust. And so if the trustees never hold that $10, the trust has never started. And there have been cases that have gone to court where people have tried to argue that a trust is a sham or doesn't really exist because that $10 has not been accounted for. And in the most recent High Court case, what the court said was that so long as the trustees can still go and get the money, it's okay. However, once the Trust Act comes into effect next year, I think it would be dangerous to rely on that. So if you're someone listening who has got a trust, when we finish this webinar today or on Monday, you need to check your trust accounts and make sure that there is a record of that initial $10 settlement. Because if there isn't, someone could later challenge the trust and say it never, ever started. And what would that mean? Let's say you've settled your trust for creditor protection or long-term intergenerational asset protection. Because we talk about this idea of protection, but what does it really mean? Well, let's say I've got valuable assets. I've taken Lucia's advice and I've got my own property portfolio worth, maybe $15 million. If I own all of that property personally and someone sues me, I'm going to have to maybe either borrow against property or sell property to pay out that creditor. But if my assets are owned in a trust, they're not mine anymore. They might have been mine, but if I've sold or gifted my assets to the trust and I've forgiven any debts owing to me, and I'll explain what that means in a minute for anyone who's not clear on that, those assets aren't mine and they're not recorded to my name anymore. On the title, it might say Vicki, and let's say Lucia is my other trustee. So the title to each property would say Vicki and Lucia. It wouldn't say Vicki's trust because we're not allowed to record the name of a trust on title documents, and we're not allowed to record the name of a trust on share registers. So if those trust assets maybe were companies that owned properties, would be Vicki and Lucia's name on the record of share ownership on the company's office. And so if someone has a claim against me, say I've done something really bad and I've been sued for $1 million. Well, I don't have any money. And so long as I have fully gifted my assets into the trust, I've got nothing. I own assets together with Lucia as a trustee, but Vicki doesn't have anything. And so what that means is that if someone sues me, they can't get any money. And that's why trusts are commonly used for creditor protection, because the idea of a trust is that you no longer own the assets. Now, you've created the rules as a settlor, so the trust deed might say that Vicki is a beneficiary, so I can benefit from those assets, but I can't be the sole beneficiary of a trust I've settled. And so the beneficiaries might be Vicki, her husband or partner, her children, her grandchildren, and those people are called the beneficiaries, or the people who can benefit. And so the trust works because it's not mine anymore. And it doesn't matter that it came from me. All that matters is that I've got a properly managed trust with these assets in it that have been properly gifted, and that protects them from creditors. Now, it doesn't mean that I might not get bankrupted, because if I owe someone $1 million, they're going to be pretty cranky. And so they can bankrupt me, but the official assignee on my bankruptcy cannot get any money from the trust unless the trust owed me money. And as I've said, I'll talk about that in a minute. So that's why. And so why is this tiny $10 settlement so important when we're talking about a potential claim for maybe $1 million? Because if that settlement wasn't paid and the trust hadn't started yet, someone could argue that that trust never began and that the transfer to Vicki and Lucia as trustees was defective and all those assets go back to Vicki. And then I'm going to have to pay that $1 million claim from the assets. So a really important part of having a trust is taking care of it and making sure you keep up with the paperwork, because that paperwork is incredibly important for the trust to work properly. And we've got a lot clearer rules now under the Trust Act than we had before. And from next year, I would say if you've got a trust and you can't point to that very first settlement, even though a whole lot of other assets may have come later, you could have a problem. But the good news is you've got time to get things fixed up before January of next year. So, okay, getting assets into the trust. That's a really important part of trust administration, and probably the area that I see people do the most badly. Up until a few years ago in New Zealand, we had gift duty. And so one of the reasons people make such a bad job of getting assets into trust is because historically we've done it really in quite a torturous fashion. And so if I wanted assets to go into a trust because of gift duty, let's say, I haven't done as well as Lucia, but I've got a house and I want to protect my house. Like I've got a business and I get advice that actually, Vicki, that's a pretty risky business. You should probably have a trust to protect that house for your husband and your children if anything goes wrong with your business. So there's two ways I can get that house into the trust. The first is I can make a gift. And it's got to be recorded in writing, but I can have a document, often called a deed of gift, that says, I'm Vicki, I own this house. I am gifting this house to the trustees of my trust, who are Vicki and Lucia. And we all sign the document, and then the lawyer does the legal transfer. So the house goes from me personally to the trustees. And that would be a way of getting the house into the trust. And that's an easy way, and it's very straightforward. But people commonly didn't do that because up until while we had gift duty, if I'd done that for the value in excess of $27,000, I would pay gift duty, and the rate of gift duty was up to 25%. So it was really expensive, and so people didn't do it. So what they did instead, and let's say this house is worth $1 million, I sell my $1 million house to the trust, and the trust has got no money. It's brand new. All it's got is that $10. And so Lucia and Vicki owe Vicki $1 million because they can't afford to buy the house from her. And we call that an acknowledgement of debt. And I can forgive that debt if I want to. And back when we had gift duty, people would do that, and they called it gifting. And every year I would say to myself and Lucia, I forgive you the payment of a further $27,000. And so that $1 million, it's each year you take 27,000 off and 27,000 off, and it might take a long time, but you keep on doing what's called gifting. Now we don't have gift duty. So if I want to get my house into a trust, I can either sell it for $1 million and immediately forgive that debt back. And there are good reasons why, and you might say, well, for goodness sake, why would you even bother with that now? Why wouldn't you just gift it? Well, because of the bright line test, any time we've got property, we need to have a value of it going into the trust in case we sell it within 5 years, and the bright line test applies. And so we normally still sell assets. The difference is I sell my house for $1 million, and at the same time, I say to Vicki and Lucia, I record that you owe me $1 million, but I forgive the debt. And that's called gifting. And we would say that that trust was fully gifted because my house has gone in. Someone sues me, I've got nothing. But if I live in that house, Lucia and I might agree that I will pay the rates and I will pay the insurance and do the maintenance because we've got no money. What that means is we've got to record those advances every year. So every year when Lucia and I should meet at least once a year as trustees, we have what we might call our annual meeting. And Lucia would say, well, Vicki, how much money have you spent paying for trust things this year? And ideally, I'd be able to say to her, right, here are my records, and I've spent $25,000. So then we would record that I'd advanced $25,000 to the trust, and I forgive that debt. So that way, all of the assets stay in the trust, and I've got nothing. If that doesn't happen, and there's a debt owing back to me because we got lazy, we got bored having meetings, or we just sort of forgot about it, 10 years' time, I might have spent $250,000 paying for trust things, and I get sued for $1 million. Well, the house is protected in the trust, but because the trust owes me that $250,000, Lucia and I will either have to borrow that money to pay that out to me to meet the demand from the creditor to that extent, or we'll have to sell the house and trade down and buy something cheaper to pay it. So managing trusts and managing them well is fundamental to the trust working, because no matter how good the trust deed is, if you don't manage the administration, it won't matter that everything in the trust deed is right. You're going to have problems if there is a claim against you. So I've talked a little bit about trustees already. I'll talk a little bit more. I've talked about, this imaginary example of Lucia and I owning a house together as trustees, but are the trustees the owners of the trust property? I often review trusts for people. I review the titles of trust ownership, and the first thing that I look at is, are the trustees recorded on the property? Because commonly, people settle a trust, or a husband and wife do, or a couple do, and they do all the documents, they do the deed of gift or the sale of the property, but they don't understand, or it gets overlooked, that they need to update the title. If there's a mortgage, they'll need to tell the bank and get instructions from the bank to allow that to happen. The next thing you have to do as trustees is you open a bank account. And we need to make sure that all of the trustees can at least see the bank account. And we might agree that only I'm going to have signing authority, but we need to have a mandate with the bank so the bank knows that account is operated for trustees. And the trustees need to know why the trust was settled. Trust deeds are often written in very dull language that doesn't explain a lot. And that's why I've talked about having a memorandum or letter of wishes. So, let's say, it's Lucia and me as trustees. My trust deed says I'm settling a trust to benefit these people. It doesn't really say what I want to happen if I'm not here. For some people, if they're not here, they want the trustees who, they might be for them educating their children. It's really important. And so my memorandum of wishes might say, if anything happens to me, it's really important that my children are educated, and I want the trustees to spend as much money as they need to make sure that my children have the best possible education. Or I might say, it's important to me that my children are helped into their first home. Or it's important to me that if I die, that my children travel. And obviously right now, COVID-19, probably not a good time for thinking about travel. But for some people have an idea of a trust is to ensure capital protection of assets so that you build up wealth. But for some people, a trust is something that might pay for just the education of grandchildren, or for extra things that they think will enhance the life of children or grandchildren. And that's why having a trustee who knows what your wishes are is really important. While you're one of the trustees, that's fine. But if you're not, you need to know, what was really intended, because the deed might not tell you very much. And now's probably quite a good time to actually think about, how is it that we ever got trusts? Because that's probably going to help make sense of the rest of the presentation and why trusts do get attacked. So the very first trusts, no one knows for certain, but the sort of historians and experts think that the very first trusts happened around about the time of the Spanish Crusades, about the 1400s. So we're talking a long time ago. And back then, you couldn't, if you were just a regular person, you couldn't bequeath your property by will. So if I'm a farmer out on a farm, I've got wife and children, and when I die, my land would go back to my feudal overlord. And the time of the Crusades, people knew that if you went to Crusades, you probably weren't going to come back. And around that time, some truly extraordinary thinkers came up with the idea of the trust. And it kind of went like this. One man would say to another man, I'm off to the Crusades. We all know I'm probably not coming back. So I'm going to give you my farm. It's not for you. It's not for you. You are to hold it for my wife and children, so that if I die, they're still protected. If I come back, you're going to have to give it back to me. So it's not yours, but you're going to hold it for the benefit of my wife and children. And that was the genesis of the very first trusts. And the thing about trusts is that they've always been there to kind of get around rules or legislation. For a while, trusts were very tax effective, but the law kind of caught up with it. And, and people have used trusts to try and get around estate duties. People use trusts to try and, manage to get assets from one place to another. And the way they did it, they could avoid gift duty if they did it carefully. But trusts have always had this element of avoidance or something that's just not, just a bit different. And so sometimes that creates suspicion, and sometimes trusts are there and they really are a sham. There's no intention that people dispose of their assets to the trustees, but they want to make it look like they have in case they need the trust, but need to protect themselves. But really, they still want to have all the control. If you're doing that, that's pretty risky, and that trust may well not withstand scrutiny. But interestingly, the Trusts Act does not say what is a sham. And there was a reason behind that, because the Law Commission decided that if they said in the Act what is a sham, that would kind of give people a line in the sand, so they would know exactly how far to go and have it valid, but not really being a proper trust. And so that's why trusts are defined by reference to intending a trust, intending to benefit beneficiaries, and having identifiable property. And if you meet that definition, you're a trust, and the rules of the Trust Act apply. So beneficiaries. The most important part of a trust is the beneficiaries. That's who's going to benefit. But you have to be really careful to make sure that the beneficiaries are actually who you intend to benefit, and that you know who they are, and the trustees know. And it's not so bad with more modern trusts. Some of the trusts settled perhaps back in the 60s, 70s, 80s, 90s, and even some more modern ones, they had huge classes of beneficiaries, because back then changing trust was very difficult. Now, it wouldn't be uncommon for a trust to say the trust is for the benefit of the settlor, any relative of the settlor's children, grandchildren, any relative, any charity, sometimes for any employees of any business or company that the settlor owns, really big classes. And the trustees knew who was really intended to benefit, but there's no other way of knowing. And what a problem now moving forward is that we're going to have new rules about telling beneficiaries. Because up until now, trusts have been really secret. And there's no register of trusts in New Zealand, and there's no positive obligation right now to tell beneficiaries you are the beneficiary of a trust. But that is changing. So under the Trust Act, there's going to be new rules about telling beneficiaries and what you have to tell them. So for a lot of people, that's why, looking at asset protection in light of the Trust Act, you've got a couple of angles to look at this. One is asset protection. Is your trust properly administered? So if there's a claim against you or against a beneficiary, are the assets, is the trust properly managed? The other is, what if you've got a huge class of beneficiaries? None of them know about it. You tell them, because you have to now. You'll have to under the Trusts Act, and then they all start demanding money. And you've got these poor trustees who suddenly have got, sometimes it might be tens or hundreds of beneficiaries making demands and challenging the trustees. They don't give them information, or challenging the management of the trust, saying, I don't think you've done a good enough job. You should have invested in this, not that. If you'd done a better job, there'd be more money. And filing proceedings against trustees for breach of trust for not doing a good enough job. So again, if you're someone who's got a trust deed after this webinar, or next week, go and look at your trust deed, see who the beneficiaries are. Are the beneficiaries who you think? And is there a ranking of beneficiaries? My practice when I draft trust deeds is that I rank beneficiaries. So, for example, if it's mum and dad and they intend to benefit pretty much exclusively from the trust during their lives, I make them primary beneficiaries. And if the children aren't going to benefit until after mum and dad are dead, I make them secondary beneficiaries. And the trustees are expressly empowered to favour the primary beneficiaries over the secondary. They can still, give them income or capital if they want to, but they don't have to. And they can focus primarily on mum and dad. But a lot of trust deeds don't say that, which means you either need to amend the trust deed or have a good memorandum of wishes so the trustees know what the settlors intend. And be very clear who is intended to benefit. Now, I'm not presenting this today the way that I might if I was doing this to lawyers or accountants. And to any lawyers or accountants out there, I don't intend to offend, but I'm trying to make this fairly accessible for most people. So I'm only referring to a couple of, I'm not referring to the Trust Act, section by section, and I'm not referring to a lot of legislation, a lot of acts, but I'm going to give a couple of examples. And Judd and Cowley is a recent case that totally explains why you need to review your trust deed to find out who the beneficiaries are for certain. In that case, a trust was settled by the settlor. It owned her house and some money. She lived in the house and for her whole life benefited from the trust. Then she lost mental capacity. She got dementia, went into long-term care. And along the way, there'd been some changes of trustees. And then they had to go to court because then they discovered when she went into care, there's another change of trustee. And then they discovered, somewhat alarmingly, she wasn't a beneficiary of the trust. She had never been a beneficiary. And so they had to go to court to say, we need help because it was always intended that she benefit, but she's not a beneficiary. And in that case, the court did something, and that what they did was they rectified the trust deed to remedy that mistake. The problem is, if there's a mistake in a trust deed, you can only rectify it if you can identify clear wishes or clearly what the settlor intended. You can't rectify to remedy something that no one ever thought about. And I'm going to talk about this case again in a minute. There's a couple of other things about it that are quite important. And so now is a time to be looking very carefully at a trust deed and looking at who the beneficiaries are. And we also have something that's commonly called final beneficiaries, or they might be called, default, and sometimes they're not always called that, but what they are is the beneficiaries who will benefit when a trust comes to an end. At the moment, under the trust law as it stands, or under a piece of legislation called the Perpetuities Act, a trust can last for up to 80 years. When the Trust Act comes into force next year, trusts will be able to run for up to 125 years. But current trusts will only run for that long if the way the trust period is defined in the trust deed allows it to run for longer. But what does that mean? Well, final beneficiaries, they're the people who benefit when a trust comes to an end. But all that means is they're the people who benefit in 80 or 125 years' time from when it started. Well, if I'm the settlor of a trust and I'm 40 when I settle the trust, it's clear I'm highly unlikely to be alive in 80, when I'm, in 80 years' time when I'd be 120. And so if we've got final beneficiaries who will not be there at the end, we need to make sure that there's a mechanism that's going to identify who benefits when it comes to an end if there were any assets left. Sometimes people are put in there by name, and sometimes they might be what we might recall as a default beneficiary. So we might say the final beneficiaries of Vicki's trust are her children. But if any of her children have died on the final vesting date, leaving children, it goes to their children. And sometimes people go further. And if there's no children or grandchildren, it goes to nieces and nephews, and they might go on and on. And sometimes they're named by name, and sometimes they might be by what's called by class or some kind of default mechanism. So it would go to who would benefit under Vicki's estate if she died intestate in accordance with the Administration Act, which is a piece of legislation that says what happens with your assets when you die if you don't have a will. And so for a lot of people right now, these beneficiary considerations are going to be hugely important, because if the beneficiaries named in the trust deed are not people you want to tell they are beneficiaries, you need to think very carefully in the time between now and January as to whether or not you can or should amend the trust deed and what the legal consequences might be if you do and if you don't. And by that I mean, if you remove beneficiaries just so that you don't have to tell them, if they find out, could they come back and challenge the trustees for doing that? We're not going to know the answers to questions like that for a while, but as a general observation, if a beneficiary has never made any settlements onto a trust, as in given the trustee's property, then that power to remove them is likely to be a power that can be properly exercised. I can't say stronger than that because until the law is tested, we won't know. But what I can say is there's only one case in New Zealand that I'm aware of in recent times where beneficiaries were removed and they went to court and got put back in. But in that case, the beneficiaries who got removed, they settled. The trust had what's called a nominee settlor. So there wasn't a real settlor who was giving money or assets to the trust. It was parents and a son who were in a business together, and they settled this trust really, but they weren't the named settlors, but only the son had the power to add and remove beneficiaries. They had a falling out and he removed his parents as beneficiaries. They were relatively elderly at the time, and the court said, no way. They said, we're not going to make a hard and fast rule, but these are people who had settled a lot of money onto the trust. And so the fact that when you do settle money onto a trust doesn't give you any rights, the court felt in those circumstances, the expectations they had of how things would work were such that they should be put back in. Doesn't mean they're ever going to get anything, but they had to be put back. Now, I said I'd talk about that case again a bit further. And the reason, one more thing I want to say about it, and now that I've talked a little bit more about, beneficiaries and ideas, it will probably perhaps not surprise many of you who have read trust deeds that often they're just gobbledygook. But if you are now looking at removing beneficiaries, it might be helpful to have some information about what you intended when the trust was settled. And what the court said in the case I talked about is that they were satisfied that there was ample evidence to support the inference that the original trust deed did not reflect Ms. Reid's intentions at the time the trust was settled. And so for that reason, the court ordered that she be added as a beneficiary. But one of the things that was really, so what that tells us is if we want to get rid of beneficiaries now or add beneficiaries, or whether or not we need the help of the court, what did we intend when the trust was settled? So that might mean going back to legal or accounting records or file notes or letters or emails to see what was intended. And what the court said here, it was clear to the court that Ms. Reid's original solicitors failed to record her intentions, and even the interesting thing here is that they actually went through changes, and they did it quite oddly and completely wrongly. Sometimes they want to change the trust deed, so they wrote notes on it to change it. You can't normally change a trust deed like that. In fact, that would be an extraordinary way to be able to. Normally, if you're going to change a trust deed, you'll have a deed of variation. But what was interesting is that although Ms. Reid hadn't realised she wasn't a beneficiary, she was confused enough by the terms of the trust. The court, one of the documents before the court was a draft copy of the trust deed, and she'd actually made a note on it saying, what the hell does all this mean? And I think that commonly people don't fully understand what's in a trust deed. There's lots of words in there that don't make sense. And either they just trust their lawyer or accountant to get it right, or they don't want to appear ignorant or foolish or embarrass themselves by asking questions when maybe they should know. It is okay to ask questions about trust deeds. In fact, it is to be encouraged because either your lawyer or accountant or advisor can answer them, can't, in which case you need to think, am I getting good enough advice? Because if you've got a trust deed, that's in a trust that's owning assets that would otherwise be yours, you've got to be really comfortable those assets are in safe hands and that that this trust deed does correctly record your wishes, because telling the beneficiaries, a whole new game moving forward. So as I've said right now, unless a beneficiary is a final beneficiary and a trust has come to an end, there is no obligation on trustees to tell beneficiaries. And I tried to argue in court last year that could not be right. And the court assured me that no, I was wrong. And we lost the case. And the court said, and why it was relevant is the court said, if trustees don't have to tell the beneficiaries, then we don't have to think about them either. Now that's quite scary, but that is pretty much where the law is at the moment. But it is changing. So from next year, while there isn't an absolute obligation to tell every beneficiary, there is going to be what's called a presumption that the trustees will make basic trust information available to every beneficiary. And so if you've got a trustee where you've got lots of beneficiaries, it doesn't matter that it wasn't what you intended or you didn't understand. The trustees have an obligation to tell every one of them that they're a beneficiary, who the trustees are and how to reach them, any changes of trustees, and that they're allowed to request the trust deed and trust information. This is a huge change in the law, and for some trusts it won't matter. Right now, if the beneficiaries are mum and dad and the children are 4 and 5 years old, it doesn't matter. But once those children become adults, the trustees are going to have to think about, are we going to tell them? Because the presumption will be that they will. Fortunately, we've got some guidance. And I'm not going to go through this in any detail because, as you'll see from the slides in front of you, it is quite detailed. There's actually these factors A through M to help trustees decide whether or not to tell the beneficiaries. But what it means is that at least every year, the trustees are going to have to consider it. And some of it, is pretty obvious. The age and circumstances of the beneficiary. If you've got a 4-year-old child, then it's not appropriate to talk about the trust. So you can easily decide that. Or you've got, the nature of the interest in the trust. Well, if it's a discretionary trust, you don't hold anything. You've only got a right to be considered or a right to ask for information. Personal or commercial confidentiality. If, depending on, there might be a trust where there is perhaps some big commercial debt or big bank debt, and if that information or details of how much debt perhaps there was, could be very commercially sensitive, that might be a reason not to share it. Or the trustees might have different investments where it would be the whole reason for the trust was to have, valuable assets held by these trustees. And it might be that by having that information suddenly go to all the beneficiaries, that there would be, real difficulty of the trustees in managing the assets because they might co-own assets with other trusts or other people and create these issues. There's any range of circumstances. And as you go through these different factors, it's also what would be the effect of giving information. So a 16-year-old beneficiary says, I want to know how much money in mum and dad's trust. It might not be a good idea for them to know that there's $150 million of assets. Because every year in New Zealand, I look at the rich list and I have a little giggle when I see it. Because although that's the best ideas out there of how much money there is in New Zealand, I've got some very high net worth clients, many of whom have never ever featured on the rich list, but they've got huge amounts of money and nobody knows, and they want it that way, and they don't want children knowing. A lot of those clients, they do work with children over time to educate them about money, and I do think communicating with beneficiaries over time is incredibly important, but it has to be on an age and stage appropriate basis. And the law recognises that sometimes giving information could be damaging within families. Or as a huge class of beneficiaries, it might be impossible. Or it might be appropriate to redact or cover up some information. Or it might be, you've got to look at the context, because if it's just so that, the trustees can be sued, well, you might say, well, hang on a minute, they're just trying to trip us up and find we've done something wrong. And so that's not appropriate. But this is a huge change. And while it doesn't strictly relate to asset protection, if the trustees don't do the job properly, then that could enable beneficiaries to challenge who the trustees are so that they no longer control the assets. And if all of the assets you've put in a trust, you lose control of those, the protection may not be what you're expecting. You're no longer part of the decision maker as to who can benefit and how. And I'll give you a practical example of that. I was recently appointed a trustee of a trust. There'd been a fight for power. The children wanted Dad and the stepwife removed as trustees. Dad and the stepmother felt that they should remain. They had court proceedings over information, and then the matter was settled by everybody agreeing that there'd be an independent trustee. Well, that now means that Mum and Dad's future, Dad and the stepmother's future, that's now in the hands of a complete stranger. And so the assets that were in that trust, and hopefully I will make, wise and sensible decisions, but when that trust was settled, they never ever thought a complete stranger would be deciding what to do with the trust property, who can benefit from it, who will live in the trust house. And so it is something that, to keep assets properly protected, trustees must do the job well so they remain trustees. There is also a procedure. In some circumstances, there will be cases where no beneficiaries should have information. That would be extremely unusual. And if that's the case, then trustees will need to go to court to ask the court how to ensure the trust is properly managed. On the bright side, if beneficiaries ask for information, because there's two aspects to the notification. First, you're a beneficiary, you can ask for information. Then the second step is if they do ask for information. Now, that is a right that beneficiaries already have, but we've now got clearer guidance as to what trustees consider in making information available, and if there are costs associated with making information available, the trustees can ask the beneficiary to pay for it, and they can require payment before they make the information available. Another aspect of the Trust Act, and I won't go into this in any depth, but all of you with trusts, I urge you to go back and look at this PowerPoint presentation after our meeting, this webinar, there will now be mandatory duties. So whatever the trust deed says, there are some certain duties that apply regardless. But they're pretty sensible. Know the terms of the trust, which means you must have a copy of the trust deed. Act in accordance, do what it says. There's a case, Enright and Enright, that came before the courts last year. It's a huge decision. It goes on for about 80 pages. And for anyone who's interested in any of the cases I've talked about today, at the end of the PowerPoint is a reference to my blog. All of the cases and aspects of the Trust Act are written up on my blog, and that's a free, publicly available resource. In Enright, they didn't know the terms of the trust. It was an old-fashioned trust deed, and there was a clause in there that said that any income that wasn't paid out was capitalised, but not capitalised so that it was trust funds, but capitalised so that it went out to the final beneficiaries at the end of the trust, and no one knew. And what that meant was that the beneficiaries, when they found out and they claimed against the trust, there was an order that they be paid $1.7 million. And so it is really important to know, just practical reasons, and now it is going to be the law. There's also default duties. And what these are duties apply unless the trust deed says otherwise. And for most people, these aren't going to matter. But one that is going to matter is investing prudently. Because if you've got a trust where all of the assets maybe are the family home, or all of the assets are in investment properties, or all of the assets are in shares, that might not meet legal standards of prudent investment because you're not diversifying the investments. And if you've got a current trust deed, it will probably have a clause that says that there is a contrary intention for the purposes of the Trustee Act or any legislation in substitution, but it's not clear to us that moving forward that will apply next year, because the Trust Act is not legislation strictly in substitution for the Trustee Act. It repeals the Trustee Act, but it puts in these new rules. And so if you don't have diversified portfolio of assets in the trust, I would strongly recommend that you have those clauses reviewed to see whether or not you need to make some variations before the Act comes into effect next year. So now, we've sort of talked a whole lot of stuff about, reasons for having trusts, how trusts work, and how the law is going to apply. Now is a good time to think about, do you want a trust if you don't have one? Or if you do have one, is it still going to work for you moving forward? Is telling your children about the trust going to create so much trouble that you don't want it? Or what if, when you settle the trust, you had these great ideas about creating wealth for the whole family and your brothers and sisters and parents are beneficiaries, but actually over time you've kind of changed your mind and you really just want it for yourself and your children? Or maybe you didn't think you were going to have children and now you have, and so the beneficiaries just don't work anymore for you. So things to think about now are, if you didn't have a trust, is there someone who could sue you? Is it really realistic that you are sued? Is this a risk that could be dealt with by insurance? Or where did the assets come from? If it's part of long-term family wealth, is it really important those assets stay within your family? In which case, a trust might be the only way you can properly protect them. Do you want to get a residential care subsidy when you're old? Well, for most people, that's achievable through a trust, but only if you keep on gifting at $27,000 a year. And if that's your sole reason and you've got valuable assets, the way the law is changing there, it is unlikely to, be something you could rely on in the long-term future. Tax. There can still be some benefits through trusts, so that instead of paying 33%, which is the top marginal rate and the trustee rate, if you've got perhaps, children or who, when they're no longer minors, because those rules until they're 16, you have to, if any income to children, unless they've got special needs, is taxed at 33% anyway. It might suit you to pay money up to the children at a lower tax rate when they're going to uni. But before you do that, make sure you know how any support you give them might affect any means tested benefits that they might otherwise get. I've talked about long-term intergenerational asset protection, and really that is the only good reason to have a trust. But even so, look at what the costs of the administration will be. Is that trust, is the administration going to be so much that even if you've got a good reason, is it worth it? You need to critically assess if that trust is still going to work for you. So that takes me to the very end of my hour. If you've got any questions for me now, pop them into the chat panel, or otherwise, if you think of them afterwards, feel free to send me an email, or if you just want information, you can go to my blog.
Thank you, Vicki. Yeah, that was quite a lot of information. So I do have a list of questions, and I'm sure, I think there's a question just coming from Eddie. Yeah. So, what is the best time to set up a family trust if I want to exclude my future daughter-in-law as a beneficiary?
Before you've got a daughter-in-law, is the very simple answer. So that if you've got a trust, and it's quite common, perhaps surprisingly common, for trustees to still say for children and their spouses. So if you want to set up a family trust that your children can benefit from, but not any spouses or partners, specify. What I do with my trustees is I normally specify in the background that it is only intended that the named beneficiaries benefit. But the other thing is, there's one little fishhook with trusts that you've got to be quite careful about. If you don't want a future daughter-in-law to benefit, look very carefully at when assets go into that trust. Because if you've got a trust that one of your children is a beneficiary of, and when that child is in a relation, is married or close to getting married, you put assets in, if it could be argued that's a nuptial settlement or there's some link to them, for example, you put a house into the trust that they then live in, even if that daughter-in-law isn't a beneficiary, she could later claim, if she gets divorced from your son, that it was a nuptial settlement, and Section 182 of the Family Proceedings Act allows her to ask the court to redistribute some of those assets to her. It's an area of trust and relationship property law that is very unpopular and is currently under review, but it is an area where you've got to be quite careful. So if you've got a trust and you don't want your children's spouses to benefit, and that's very commonly the case, A, don't have them as beneficiaries, or if they are, remove them, and B, make sure you don't settle assets onto that trust during a marriage or relationship if there might be a claim later. And what that can mean sometimes is you might want to put assets into a trust. You might choose not to name the children at all, but you might instead say the beneficiaries are, my wife and me, but when I die, then my children are beneficiaries. So sometimes we have to think a little bit about, there's no one size fits all with trusts, and what might make good sense one year might not make good sense another year. So keeping up the administration is important. Thank you.
Yeah, and how about, can you actually kind of like quickly explain this relationship property? Because I think last year there was some talk about changing the rules about the relationship property.
Thank you. There's been a 5-year review of the law of relationship property, and recommendations were made to government. Unfortunately, it's been shelved for now because there's now going to be a review of succession law. So we don't expect any changes for maybe another 4 or 5 years. One of the changes being proposed, one of the aspects of relationship property law that is very unpopular, and why a lot of people do have trusts, is the fact that after 3 years you share equally in the family home. So a lot of people have trusts because of that. It doesn't always work very well, and if you've got a trust and concerns about relationship property, you really need to have what's called a contracting out or Section 21 agreement as well. Try and make sure that those trust assets would be properly protected if you split up. So we don't really know what the law will be moving forward, but we expect there will be changes. But I reckon we'll be maybe 5 years away before we've actually got new legislation. Thank you.
Okay. All right. So we got another question from Jay. At what value of assets is it worth making trust?
That's a really good question. From my perspective, you've got two ways of looking at it. It's not so much the dollar value of the asset, but the value of the asset to you. And if we say it's a house in Auckland, you're not going to have a house in Auckland for under $1 million, realistically. And so if you've got a $1 million asset, that for most people, I would say, is worth it. But what if you've got a lot of bank debt as well? So you've got $1 million house, but you owe the bank $800,000. So it's really only $200,000. So what's it going to cost you then to protect that $200,000 of equity? Setting up a trust costs about $1,500. Some people a bit less, some people charge a bit more. Transferring the house might cost you another $1,000, and then having if you've got a professional trustee, your fees for keeping up with your gifting each year. So if you pay the mortgage and each year the trust has got a bit more equity because you've paid the mortgage, gifting that off each year, that's probably going to cost you, and I would say that's going to cost you maybe another $1,000 a year. And so over the course, spent maybe $25,000. And you settled that trust, you had net worth of $200,000, and you spent $25,000. So maybe 1/8 of the value of your, was that $25,000 worth it? And if you have to start telling beneficiaries that they are beneficiaries and they start challenging you or trying to get their hands on trust assets, you might think this is more trouble than it's worth. I wish I hadn't bothered. So what I say to people is look at the value of the assets, look at what the annual cost will be, and also look at, if you're just doing this for creditor protection, could you insure against that risk? Because if you can insure against the risk, and you've got, assets that are important to you, but not enough, if you've got big family wealth, I'd say anything from like maybe 15, 20 million on, that's enough wealth. It's really smart to generally have it in a trust, because it's not just the protection aspect, but it's having more heads involved. It's having more thinking, more and making sure you educate the next generation so that they don't make stupid decisions. Because one thing I've seen, you see this, you hear the jokes about it, but a lot of them are very true. You have the generation that makes the wealth, the generation that enjoys the wealth, and then the generation that spends the wealth. And so trusts can be a great way of avoiding that diminution. And so for big amounts of money, I think once you get to, and 15 million is just like a made up number, but for me, I think beyond that, you're really looking at, that's enough money to really want some serious, long-term planning in place. And under $1 million, I think you've got to say, could I insure against that risk, or is it worth it? But also remember, from little acorns come mighty oaks. Look at what Lucia has achieved in a relatively short space of time. And if that's all done personally, all her capital gain would be available to creditors. But if it's done in a trust, all that capital gain is protected. But I think, I do see a lot of trusts where the only asset is the family home. And I have quite a lot of work I get from people where mum and dad want to go into long-term care. They would get a residential care subsidy, but for the trust. And so we wind those trusts up, explain what happened to MSD, and then we get a subsidy for them. So it is horses for courses. But I think below $1 million, look at the risks, look at, can you insure that risk elsewhere, but also make sure that you are okay sharing control, because a lot of trustee people struggle with the idea that they're no longer strictly in control. And I can remember, just after I'd settled, I have a family trust, and not long after we'd settled our family trust, we were investing in residential property. And for me, it was in my head, well, we'll have that in the same family trust as owns, the particular property that was in there. And my independent trustee said, no, this is a really significant family property. I don't want anything that would expose this, and I don't think you should use this trust. And while it was great to have that discussion early on and decide how we would treat different aspects of investments within our family, for me, it was really quite a shock having my independent trustee not just do exactly what I thought should be done. And for me, that makes our trust quite robust, because we do really think about things. But for some people, the idea of someone saying no, they can't handle the idea. Thank you.
Yeah, okay. It was a bit of breaking up, but I kind of summarize it as like setting up a trust as $1,500, and then also the transfer of the property is $1,000, and also the annual administration is probably another $1,000. Yep. So you're looking at like over time, it's probably $25,000 for the trust. And I think you mentioned about $1 million mark. But is it $1 million kind of based on at the moment? Because obviously, inflation, the house price goes up. That's probably going to be changed. And at the end of the day, it's always case by case, because everybody have different need. Yeah. Okay. Right.
Correct.
Yeah.
And if you've got a house and your only asset in the world is $200,000 equity in that house, you would still, and you've got a risky business, and people who generally need trust the most are probably builders, architects, engineers, professional directors, because they're the kind of people that get sued the most. And 200,000 might not be a lot for some people, but if that's all you've got, that's an awful lot. And that might be the difference if you get sued between keeping your family home and not. You've got to balance the risks and say, if you're an employee with no risk of being sued, maybe think about, do I really need a trust?
Yeah, okay. Good. Yeah, thank you, Vicki. So we got a question from Victoria. So can you put things in a trust if you don't own a property outright?
Yes, you can. So what would happen is, say you've got a house and you own it and you've got a mortgage to a bank. What happens is you go to your lawyer, and when they settle the trust deed, what they do next is they then write to the bank saying, we'll use Lucia as the example. Lucia has settled a new trust. She's got a house. You're the mortgagee. Can we please have new instructions? And so then what happens is the bank the most normal scenario is then either the trust has the borrowings and the person and you guarantee to the bank that if the trust doesn't pay them, you will, or you have the borrowings and the bank lets you keep the borrowings. The trustees guarantee that if you don't pay, they will, and there'll be a new mortgage so that your mortgage to the bank is discharged, the title's transferred to the trustees, and a new mortgage goes on the title. And banks are really good about transferring properties to trust because banks kind of ignore trust. They just look through to you. They don't look very much generally at your professional trustees. They just look, if you can afford a house now, then they've got no problem generally with it going to a trust.
Okay. And what would be your advice for the first home buyers? Do you think they should really look into the trust? Because foreign it can be a bit overwhelmed, with buying the first house. Is already busy now, the properties, the mortgages, and yeah. So is it also? Do you think it's worthwhile for them to look at it at that time, or maybe a bit later, or yeah?
It's cheaper to do it at that time because then you don't have to transfer the house later. Any capital gain, everything is protected from the start. But for a lot of first-time buyers, they can't have a trust because if they're getting KiwiSaver, using their KiwiSaver towards it, you can't have a trust own it. And so for our first-time buyers who, so in my firm, although I specialise in trust law, I do have other staff who do conveyancing. And so if we've got a client who's a first-home buyer and they've bought a house, if they want a trust, we normally put a reminder up and go back to them in 6 months' time saying, when you bought the house, you thought you might want a trust. Now do you want to think about that again? Because if you're using KiwiSaver, it's a term of the KiwiSaver, if you use your KiwiSaver as a first-home buyer, that you must own the house and live in it. And if there's a trust, even though you're going to live there, they don't allow trustees to purchase, but you can later then transfer the house to a trust afterwards. And there's no rules about how long you have to have it if you use KiwiSaver. Generally, most people look at it after about 6 months and decide, do they want to trust at that point? But I agree with what Lucia says. Buying a house, especially the first one, there's a lot to do. And for some people, it can be really overwhelming. And even if it costs you a little bit more, it might be a good idea to buy the house, settle down paying the mortgage, and then think about, do I want to trust?
So at that time, is it better to do a sale, them sell to the trust, or it's a gifting? Because that's kind of blind eye test that kind of also come in, and possibility of the, yeah.
My preference is nowadays is the straight gift, and how I normally do it, because it makes the administration a bit easier, is what I normally prefer is that the client retains the borrowings, like a sale, so the trust has got a figure for the bright line test. So if we use the example, I've got a house worth $1 million. I'm going to sell it to the trustees for $1 million. They owe me $1 million and I forgive that debt. I still owe the bank maybe $800,000. I will keep on paying it, and that way I don't have to advance the money to the trustees for the trustees to pay their borrowings. And then each year or two, I'll add up what I've paid on insurance and rent and maintenance, and it won't be very much. And so you don't have as much administration. And sometimes a bank for whatever reason won't allow that, but that keeps it really simple. The other option is I've got a house worth $1 million with $800,000 of borrowings. I sell it to the trustees for $1 million, but they take over the $800,000 of borrowings. So they effectively pay me $800 by taking over those borrowings, and then they owe me $200 and I forgive that. And when that happens, what that means though is that I've got to keep on advancing those mortgage payments to the trust. And so there's a bit more administration to keep up with, and you need to look at doing more gifting more often.
All right. So your suggestion is like do a gifting, just change the ownership, but the mortgage is still under their personal name. Yeah. And then they just do the
and sometimes you need the trust will give the mortgage security as owning the property, but the loan stays in your name. And the one time you definitely want to keep the loan in your name, if you've got a fixed term loan, the bank will let you keep that fixed term loan and transfer the house, whereas if the trust took over the loan, you'd have break fees to pay. And that's really important right now, because with interest rates getting lower and lower, if you've got a higher fixed rate and you break it, the bank will charge you penalties.
Yeah, because I think it's probably less drama for redoing the mortgage as well. It's basically just some paperwork. The guarantee need to be trusted, need to provide a guarantee and sort of things there. Yeah, okay, that's good. All right, we got a question from Tob. Best way of income splitting. So I'm not quite sure whether this is talking about like like allocating the income to the beneficiary. It sounds like, yeah.
I'll give you a couple of answers, Torben. If I haven't answered what you wanted, just flick me an email. Income splitting is when, let's say the trust has got either income from money, and say you've got a term deposit and you've got $20,000 of income. If the trust gets that income, it's taxed at 33%. And so that's going to be $6,700 of tax paid. Instead, you might have children at university, and so you pay the income out to them at $10,000 each. That means their tax is paid at their lower rate, and there's some special rules that work with trusts so that trustees, even if they've paid income tax on the money directly to the bank, they can still effectively share the benefit of it so that less tax is paid. And the beneficiary, and it kind of makes sense. If you've got money and a beneficiary who needs it, it's better to pay less tax and have a beneficiary on a lower rate get the money, rather than the trustees keep it and pay the tax on a higher rate. But if you are income splitting just to pay less tax, but you don't intend the beneficiaries to get the money, don't do it. There are lots and lots of trusts where the trustees pay money out to beneficiaries, pay the cheaper tax rate, but they don't give the beneficiaries the money. And IRD is getting pretty wise to this, and it can be considered tax avoidance, or it can make the beneficiary a set law for tax purposes, and there can be a requirement to pay interest at the FBT rate on that money sitting in the beneficiary's current account. And worse, if you've got a beneficiary with a current account and you tell them about the trust because you have to, and they discover the current account, they're going to want the money. So income splitting can be a really great way of benefiting different family members at a lower tax rate, but you've got to make sure you look at all of the aspects of it. Thank you.
Yeah, okay. Something to add on is like the beneficiary is 16 years old or close to it. And so I think that your accountant will actually kind of handling that. And basically all you need to do was come out with a spreadsheet like how much you spend for those kids. Yeah, so it might be the overseas trips, just something on top of that necessary, overseas trips, like getting their teeth done, or like a additional private school fee or something like that, yeah. Mm-hmm.
The other thing I would just a warning though about income splitting, you can do all the right things and still get it wrong. Just be really careful if the beneficiaries are overseas, because if you've got a property that the white line test applies to, so maybe you've got a house and a rental in a trust, and you sell a house that the white line test applies to, if you've got a beneficiary overseas, it doesn't change the amount of tax you pay, but if you've paid out money to a beneficiary who's overseas in the last 4 years before you sell it, you've got to pay that tax. There's a withholding on the sale. So rather than accounting for the tax under the bright line tax in the next account, you actually have to pay it to Inland Revenue on the sale of the house. And if you're buying and maybe going to buy something else at the same time, that can be a real problem. But just be a bit careful if you've got overseas beneficiaries.
So definitely, you need to talk to your accountant about it, and certainly having the trust a lawyer like Vicki. Yeah. Okay.
Anytime you've got a trust, anytime you're going to buy and sell property, I think always talk to your lawyer or accountant first, because there are so many new rules. There's a lot of different tax rules, especially that have come around in the last few years. And there's a really good example of people getting the white line test wrong. Two houses were sold to a trust. One was on Waiheke Island. The trustees sold it. This is when we had the 2-year white line test. They sold it less than 2 years later. They made a profit of, from memory, about 1.8 million. And that's why, and I can't tell from the decision whether maybe they hadn't sold it into the trust at the right price or they just had amazing capital gain. And that's why I do think any transactions property going into trust should always be, while we can gift, I still think it's generally better to sell at market value and forgive the debt so you've got a value going in. And in that one, the trust had to pay $800,000 because they didn't know about the white line test, and then they sued their accountant, and then it went to court. And there was a question over whether or not they had asked the accountant for advice, and it did, and the court did identify the lawyers had actually given them advice about the white line. So before you enter into agreement to sell a property owned by a trust, always check with your accountant or lawyer.
Sorry, kind of breaking up. So they did actually check with the lawyer, did actually give them the advice on the blind eye test, is it?
The lawyer it wasn't clear whether it was specific to the sale or just generally, but it was the accountant they sued because they thought the accountant should have given them more advice.
Okay. All right, okay. All right, we got next question. Sean, if a trust has liquid cash and the trust is wind up and distributed, is that cash taxable?
Okay, it will depend on the trust classification for tax purposes. Today we've talked about discretionary trusts, and that's a trust term. For tax terms, there are 3 categories of trust. There are what's called a complying trust, non-complying, and foreign. Most New Zealand trusts are complying trusts. And so if you've got a complying trust, all distributions, so an income distribution such as if you had dividend income from shares or interest income, that gets taxed. Any income, anything other than income that is taxed, is distributed tax-free. So any capital and the money in the bank, if it's not, all of that, you can distribute tax-free to the beneficiaries. But if it's a foreign trust or a non-complying trust, there are different tax rules, and depending on where the money has come from, it may be taxable. So again, if you're going to wind up a trust, before you do that and distribute the income, get some tax advice from your accountant.
Okay. All right. So next one, it's from Chrissy. Difference between family trust by lawyer or one by public trust?
But other than different drafting styles, they're exactly the same. So public trust does trust deeds where they are the trustee, but they will also provide trust deeds, as part of the services they offer. And the only difference is that generally, if you've got a public trust, it might be one that's a bit more straightforward because they're sort of working at the level of, providing a general sort of trust, perhaps, rather than one that might be a bit more specialised. But I might be being unfair to public trust. If you've got a lawyer who's specialising in trusts, it might be, and someone who's worked with you for a long time, they might have more knowledge about you to help ensure a trust deed that's more fit for what you want.
Yeah, okay. So from Johnny, do you need a professional trustee? What is the cost of having one? And what is the annual cost of good trust management? I think we kind of cover that, isn't it? Like, maybe
yeah,
I just
we have. But to answer unless some trust deeds require that you have an independent trustee, that is normally someone who can't benefit. They don't have to be a professional. I recommend at the moment it is good practice to either have a professional trustee or to be getting advice because of all of the changes in trust law at the moment. Sometimes I've seen some lawyers and accountants be really bad trustees, and I've seen people who don't have any particular qualifications be really good trustees.
Yeah, okay. Another question is that I come across seeing like the customers, they have a trust set up, but they only have a corporate trustee. And then basically it's themselves as director and shareholder, like blah, 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 trustee limited. And that trustee limited actually is as a sole trustee for the trust. So what's your thought about those one?
I generally don't like, you've got to look at the trust deed, because sometimes the trustee will actually say, if there's a corporate trustee, it cannot be controlled by the settlors. However, so long if the trust deed provides it, I don't have an issue with, say, and I'll use the generic mum and dad trustees. If mum and dad are the trustees through a corporate trustee, that can be perfectly fine. And if one of them loses capacity, it can be easier than a court application, because it can be easier to change the directors. But what I always say is, if you are the sole trustees, you're taking a bigger risk. If there's going to be a challenge, it's going to be harder. It's going to be harder to defend yourself as being the trustees and being different to the trust. And also, if you don't have any professional oversight, are you doing a good job? There was a case a few years ago called Rosebud, and that was a case where the corporate trustee started off with the accountant and lawyer as directors. They didn't really like what was going on, so they resigned and the wife got appointed, and that trust was found to be a sham, because the court said that the wife had no idea what was going on, and they felt, and that was a trust that was kind of set up to benefit a bankrupt. So there was a bit of other naughtiness going on. But if you keep the trustee class too little like that and try and be a bit too clever, sometimes you're just opening yourself up to challenge. There are some, couples or, mums and dads who do a great job of trust management, but generally I think you're taking a real risk if you are the sole trustees.
Yeah, okay. All right, we got a question from Cheryl. Is it the best way if the family trust settle a house and the settlers guarantee the mortgage? Can the trust still protect the asset in the trust, or gifting is the better way? Thank you. And you guys are amazing. Thank you, Cheryl.
Thank you, Cheryl. It doesn't, from my perspective, it really doesn't matter so long as you keep up with the administration. But the one thing I'd say about that is just, I do think if the borrowings stay in the hands of the settlor, it does mean you've got less gifting to keep up with. But if you've got good discipline, it shouldn't make a difference. But the only other thing is where it can do is, if you are, say you're a director, if you've got all the borrowings yourself, but you don't, and the trustees guarantee your borrowings, the only thing you need to think about is that you might be technically insolvent. You've got $800,000 of borrowings and you don't own anything. And for a lot of people, that doesn't matter. You cash flow solvent because you can meet your debts as they fall due through your employment or whatever income you've got. But if you are a director of some companies have banking covenants where directors have certain solvency requirements. So in some situations, having a lot of debt and not having an asset could be a problem for other reasons. It's not a trust reason, but it could be relevant for other aspects of your professional life.
Okay. Hi, yeah, just a couple quick questions here is that you mentioned about this $10 settlement fund. So what happened if it's 4 people? Because I kind of think about it might be a people that haven't done this $10 one. So is it too late for them to actually do a transfer, to settle that $10? What should they do now? Yeah.
If you've got a trust and you know that $10 was never accounted for, put it in the bank account now. What a lot of people have done historically is they've kept it, stapled it to a trust deed. It might be in the lawyer's office. I just don't think that meets the requirements of the Trusts Act moving forward. So simply, if it's not there in the bank accounts, I would ask the accountant to, I would put the $10 in the trust bank account and get the accountant to refer to it in the accounts to note that settlement has been paid. And I think it's just not worth the risk, because people like me, it's my job half the time to try and find a way to challenge a trust. And if I was challenging, I've got a matter I'm working on I'll give you a generic idea. Say someone, I've got, a client has got a dispute with someone, they sue them, and they come back saying, all my assets are in a trust, and so you can't have anything. What I then look at is the first things I do, we then ask for the accounts, and I look at those accounts, and I look at, can we identify that first settlement? Can I argue the trust is a sham? Or I look at the value of the assets and the gifting and think to myself, does that add up? Or is there a whole lot of gifting that hasn't been accounted for? Has this settlor paid for a whole lot of trust stuff that hasn't been accounted for? So are they really owed money? Can I challenge the trust? And so that's why I think it's always worth the bother of just updating it to account for that settlement now, because otherwise someone like me later might be looking it up.
So better go and see you first then. Yeah. The other question, the other one was in terms of the beneficiary, because obviously that's actually in the new trust law, it's actually so clear that the beneficiary, you definitely had to actually tidy up this beneficiary, because I've seen quite a lot of trusts that they will have this very wider idea of that. Yep. Any charitable trust, basically any charity in New Zealand, and I think that's horrified. Yeah, so I guess that for lots of you out there, you probably wanted to actually relook at your trust and then maybe talk to Vicki about it, and you had a bit of tidy up, in terms of beneficiary. Another one is at the TC, because you probably know the accountants, they're very formed of at the TC, and I think as a lawyer you are probably not so formed about it, because the reality is that it's very exposed. All the it's not really actually been protected. Yeah. So what's your view about it? Yeah.
I think we're going to see a lot less look-through companies moving forward, because they've been very popular for owning rental properties and negative gearing, and now with the new ring fencing rules around rental income, I think a lot of companies that are look-through companies, some people may decide that they don't want the look-through company anymore, but they'll just transfer the shares in the look-through company to the trust rather than have to do the conveyancing of the houses. I think look-through companies for the right reason are absolutely fine, and the ability that you've got to offset losses against income can make look-through companies, really practical, but they're not going to work very well for owning property moving forward. And of course, the exact point you've made, Lucia, if your assets are in a look-through company, you might have some tax effectiveness writing off losses, but all of your equity in that company is exposed.
Yes, yeah. All right. The other one is 80 years. You talk about the trust is only valid for 80 years. So what happened when it's due? Like, do they have to actually wind up that trust, or what's
At the end of 80 years, a trust vests or comes to an end, and you can't stop it. And some people have really mucked this up. So let's say you've got an old farming trust, or it might have a shorter perpetuity period. It doesn't have to be 80. It could be a different period of time. When the trust gets to an end, any assets left in the trust are held for the final beneficiaries. So most trusts, they would dispose of the assets before that end date. But if they don't, and I've seen people get this so wrong, say you've got a farm and say it's worth $3 million and there's 3 beneficiaries. If you get to the final vesting date, that farm is then owned by those 3 beneficiaries as tenants in common to a 1/3 share each, because when the trust vests, the assets go to those beneficiaries. And sometimes I've seen people where they know it's coming to an end, they've got a plan, they think they'll sell it, and then they'll decide how to divide it up amongst the beneficiaries. They lose track of time and it's late. And it might be that one of the beneficiaries was working on the farm. And so the plan was, he's going to get more when we sell the farm because he worked there for a long time, or, sometimes it's a she, but more often it's, one of the sons. And so we'll give him more, and then so maybe we'll give him half and divide the rest up between the siblings. Or maybe those siblings, they got a benefit, they got paid money because they didn't work on the farm. And so they got, money before the trust was wound up, and so it's quite fair that the other beneficiary gets half the farm, except that they don't get around to it in time. And on the vesting day, it is absolutely prescriptive. It's like getting a speed camera ticket. you get the ticket, that's it. There's no going back. You can't say, oh, but, I meant to go slower. I wasn't thinking. I promise I'll try harder next time. You've got the speed camera ticket and that's it. Or a speeding ticket on the road. If you get 100 demerit points, bang, you've lost your license. You can't go back and say, oh, but I really, really, really hadn't meant to speed. I'm really sorry. Let's fix it up. It's like that. It's all over. And so managing those vesting periods can be really important.
Okay. All right. Yeah. Thank you, Vicki. I think we kind of done all the questions. Yeah. And I think Vicki has got a special offer for, the people who are listening to this webinar. I don't know. Do you want to tell everyone?
I do. So anyone who wants a trust review, our normal fee for a trust review is $750 plus GST, which and that reflects I charge on an hourly basis, and that effectively reflects about an hour and a half of my time. And that's a review of the trust deed, all of the trust documents. Often it'll be a lot of emails and questions to try and figure out exactly what's happened. And then we either provide a written report or we have a telephone meeting. For anyone who's listened today who wants a trust review, we're doing it for $375 plus GST, but you will still get the full hour and a half service of a review of the trust and either a written report or a telephone meeting talking about what we think needs to be done. And the reality is some trusts will need very little change because of the Trusts Act. Some trusts will need a fundamental rethink, but there are very few trusts that won't need some amendment because of the Trusts Act. And if you want to take up that offer, if you just let me know that you listened to this webinar, and I'll know if you've said you've done that you will have.
Thank you, Vicki. Yeah.
A hard thing to make up.
Yeah, thank you, Vicki. Yeah. All right. Yeah. And thank you, everyone. Yeah. I mean, you have been staying with us for a big while. Yeah. All right. Looks like we got no more questions. Yeah. And so thank you for listening, and thank you so much for Vicki. And I'll see you next time.
Thank you very much, everybody.
Yeah.
Thank you very much, everybody.
Yeah.